Thanks for joining us. You should be able to hear me and as well as see my screen. And um, just wanted to welcome you all to East State Academy. As many of you know, we launched a new portal on East State Academy in our first course, which is fundamental course about estate planning, just sort of the basics of how to talk to clients about will planning and things like that. And I know many of you have joined, so that's wonderful. And we will be releasing new groups of different topics and things like that over the course of the next months or so. And so today's presentation is on drafting simple gifts. And you'll recall from last week that we were talking about how many issues there were in simple gifts. Today we're going to actually just deal with, I had hoped to actually, or thought that we might do every type of simple gift today in drafting, but what I found is that there's enough to deal with just on simple cash legacies for today's session. And then next week, we'll talk about bequests and devises of real property. So you may recall, if you were here last week, that we talked about there were 8 or so top issues that one has to consider when planning for even the simplest of cash legacies. And we're going to run through a bunch of them, but from a drafting point of view. So the first, so here's our example clause. Your typical payment of a specific cash legacy, in this case to one individual. And that's what we'll sort of concentrate now on. So just to break this up, break this down actually, we wanted to highlight a bunch of issues here. So the first one I just wanted to talk about is we've used the words and the figures for the amount. And Rodney Hull, who was a mentor of mine and one of the top state lawyers in the country before he passed away, I once asked him, well, what do you suggest I do? Should I use numbers? Should I use just words? And he said, I would stick to numbers, because how often have we seen it where the numbers don't match the words? And so I always used only the numbers. I think that's fine. Now that we use software, I never have to worry about that it's going to say it's going to have a different number and a different set of words. So now typically we use both. It's just automatically included. But if you are manually drafting, I would suggest that you don't use both words and numbers, because there's no great benefit to it, and the downside is tragic. Obviously, I just wanted to talk about that one issue first. So that's the first thing. So here's our example. Now, the first issue that we'll talk about is lapse. The idea that the gift could fail if Elizabeth Smith was not alive. So what happens to that gift? So by common law and by our statute, a lapse of a specific cash amount automatically falls into the residue, unless the beneficiary of that gift was a child or grandchild or sibling. That's the first issue. If it's one of those and there's no contrary intention in the will, then there is an automatic gift over, in essence, to that person's next of kin, as if they had died intestate. So for example, if Elizabeth Smith, let's say the sentence ended to Elizabeth Smith, period, and that was the gift. And Elizabeth Smith was a child, grandchild, or sibling, and she died before the testator, then that gift would go to Elizabeth Smith's next of kin. So it would go to a spouse and children without a preferential share, but it would go to spouse and children if she had. So that's the effect of Section 31 of the Succession Law Reform Act, called the anti-lapse provision. It saves a gift from lapsing to residue in those very specific situations. Often we don't want to have it have the anti-lapse provisions apply. And so we need a contrary intention, even because a contrary intention will oust the impact of Section 31, even if they're a child, grandchild, or sibling. The words, if she is alive at my death or at the survival date or some sort of statement like that, is a contrary intention. Okay. So that's why you often see a clause like that with respect to a legacy to a person, because what that's saying is it's a conditional gift in essence. It's only going to them if they're alive. If they predecease, it is going to fall into the residue of the estate. Now, there's a second clause there, for her own use, absolutely. And you see that often. That by itself has been held not to be a contrary intention. So if you typically draft it to say to Elizabeth Smith for her own use, absolutely. If that person, if Elizabeth Smith was a child, grandchild, or sibling, the anti-lapse provisions would apply. At least under certain case law, there's case law that says specifically that that alone is not a contrary intention. So look at your drafting. Just so you know, any of the drafts that we're using here are generated by our software. So that's, if you're using our software, it's going to have the contrary intention automatically. The next issue is indexing. So often the amount of the legacy, the client may want to have that automatically increase each year post the signing of the will to the date of death to reflect inflation. So they don't want to have to keep changing their will, and they want whatever the amount is to be indexed. And so what you want to do in that case is indicate that, obviously, because absent that, it won't be indexed. It'll be the amount, the fixed amount, and whatever it happens to be worth at the time of death of the testator, they're going to get that amount. So, but if we want to index it, then what you can do is put in a definition of indexing. So in our precedent, in our template, it indicates for any indexed gift that uses the word indexed, and then it says that any amount that uses that word indexed means that you adjust it so that, whatever the date the payment is made is adjusted. You adjust it for the consumer price index. That's not unusual to use that as a method of indexing. You could, if you wanted, draft around that and put in whatever percentage, 5% a year. You'd want to be very specific about that. But this one is just fixes it to inflation in essence, so that the fact that they're getting the equivalent of $150,000 at the date of death. So that's the indexing. Just to remind you, if anybody has questions, or you can feel free to use the chat feature in Zoom. So that covers the indexing thing. And it's often something that, we don't think about all that often. Obviously, for those of you who use eState, you know that that's one of the options. So the next issue is currency. So what happens if it's silent? And in most cases, it is silent. You just say pay X dollars, and you don't refer to currency. So we have to go back to 1742 and the case that we all are familiar with, the Saunders and Drake case. I'd never heard of it before I wanted to just address this issue. But basically, you use the currency of the residency of the testator. So if they live in Canada, it's going to be Canadian dollars, absent a contrary statement. Now, it is a question of interpretation. So if there's some evidence that they meant something different, but absent that, it's going to be based on the residency. Some cases talk about domicile of the person, but you can basically understand it. I understand it as the residency. So now we're going to get into a couple of more complicated issues. And the first one is the issues of abatement and priority, which is always the risk with cash legacies, as opposed to, they're always the risk when you have certain amounts of money that there might not be enough money to satisfy all of the amounts. And that is what abatement is about. There's insufficient assets to pay all of the cash legacies in full. So the default rule is that they abate ratably. So in this case, we have John gets $100 legacy, Susie $200, Frank $300. The total legacies are $600. So you take that, and then you look at what the total amount of assets to satisfy those legacies are. And in this case, as an example, there's only 300. So basically, everyone's going to be pro rata. So John is going to get 1/6. So it's 100, which was his full legacy, divided by the total amount of legacies is 1/6. Susie's is 2/6, and Frank's is 3/6. And so John is going to get $50 if you multiply his 1/6 multiplied by the total amount. The 300 is $50. Susie's going to get 2/6 of the amount available, which is $100, and Frank is going to get 3/6. Yes, I could have reduced the fractions, but I just wanted to show the calculation. So that's how it works. And so that's if there's no other provision in the will. And right now, of course, we're talking about the simple, right? The whole focus of this is very simple cash, absolute cash legacies to a person. So what do you do if that's not what the client wants? And I would almost, as a matter of course, raise the issue of priority if we're giving any significant amounts that even there's a chance of a priority or abatement. And so we want to think about a priority situation. So this is our sort of standard language that if you've put certain priorities on legacies, this is what the language that is generated. It says if there are insufficient assets, then I want the legacy in this paragraph to be paid in priority to other legacies. And then I want the next priority legacy to be paid. And you can group them together. So you can say, the legacy 1 and 2, they would be paid first, and then then the third one, you can do whatever you want. And the drafting works, but this is just an example of how you might prioritize the legacies. And obviously, whenever you're doing things manually, you got to always double check your references, your paragraph references. So that's the issue of abatement and priority, and it's pretty simple. Just to go back for a second, when would I especially use these priorities? If the client wants to leave a large legacy to one individual in priority, let's say it's where the spouse is not alive, it's going to the kids, but they want to leave a large legacy to a charity, let's say. I would always say to the client, okay, what happens? Like, what happens if there's not enough money for the kids? Like, let's say there's just enough to pay the legacies. That means that charity is going to get your entire estate. Oh, I don't want that. Well, then what's the minimum that you'd want to give to your kids before that gift is given? And so we build in a priority legacy for the kids of whatever that amount is. Then the next priority legacy to charity, and then the balance of the residue, obviously, to the kids. And that way, just in case there's not enough money, the charity is not going to take the vast majority of the estate. So that's one example of when you might use priorities legacies in a simple situation. So the next topic is Hodgpod. So let's say some money has been provided to the legatee by way of advance. So they got some money to buy a home in advance or something like that. And the client says, well, I want to give them a legacy, but if they don't pay that money back, I want them to discount the legacy by that amount. We're familiar with that in residue, but it works similarly in a cash legacy. And so what you're doing here is you're basically saying, if I've advanced money, in this case, I actually have advanced money, I want to deduct that if it's unpaid at the date of my death. So you'll see in the drafting here, we have a statement about the existing advance. Now, it may be that you haven't advanced any money to the person, so you might not include this at all. But let's say they come to you and the client says, yeah, I've given Liz $5,000 and I want that to come off her legacy. So you'd include that at the beginning. And then you might also want to recognize, and again, these are all options that you want to consider when you're building a Hodgpod clause, but you may also want to consider future advances that you might make to her after the date of the will. And so if you want to include those, then you're going to want to address that in the drafting. And what I typically do is, if we're talking about future advances, the hodgepodges are basically an excuse for somebody to fight. And so we want to make sure that we can document future advances, that not everything is going to be counted against their share. And so what I typically say is that, it's only advances that I've documented it, in writing. So that's how we keep track of future advances. Oh no, so you took Liz out for dinner. Mom wanted you to count that against the share. Well, we don't want to have to get into that kind of accounting. So whether legally constituting a debt or not, that's the whole point really of a Hodgpod clause. If there's a debt, if it's a legally enforceable debt at the time of death, well, then they're going to have to repay that before they get anything from the estate. So we're more concerned about things that aren't legally a debt or can't be enforced because of statute of limitations or limitation periods or some other excuse. So we don't care whether it's legally enforceable. We're counting this against their share. Okay. And then we define what those amounts are called: deductible advance, and then Liz is the benefiting recipient. By the way, I'm going to address questions at the end, just in case you have asked. I noticed there's a couple of questions, and we'll get to that in a moment. So that's the first part of the Hodgpod clause. And then that's really just setting out the background. And now we're going to actually draft for dealing with it. So the first issue is, should there be an interest accruing on that amount? And so this is another optional choice that the client has, but something to be addressed by the client. Then if there is going to be interest, when are we charging interest? Are we charging interest from the date of the advance? Are we charging interest only from the date of death to the date that they would repay or basically receive the money? Be deducted, in other words, from their amount. So that's the first question. Then we have the actual Hodgpod clause. This B is really the Hodgpod clause, and it says that to the extent that they did receive a deductible advance that hasn't been repaid, and again, if there's a question of repayment, I want that documented in writing, and I would warn the client about that, because it's important to because somebody will say, oh, I paid that back. I paid that back long ago. And that's a common response, and they may have, but without evidence, it's very difficult. So basically deduct that amount from the legacy. And then there's another choice here that would otherwise be paid to the benefiting recipient. So that's, in this case, Liz. You should also consider, well, now, is that going to come off if there was a gift over? Is that going to come off the gift overs amount as well? So for example, if it went to Liz, and then if Liz wasn't alive, the 150 went to her issue. Well, if Liz never paid back that $5,000, should that $5,000 come out of the 150 that's going to her issue? So that's, and maybe at the end of this, I'll just show you how you can put those options in. So those are the options there. And then the last clause just says, okay, once you've taken account of that Hodgpod amount or the deductible advance balance, then forgive it. If it's a legally enforceable debt, forgive it. So that's the idea. So that's just a Hodgpod clause for a legacy. We have about 10 minutes left, which should be perfect. Let me just skip ahead. And yes, so we have 3 issues to go through, which is going to be perfect. So the first one is, what about legacies to minors? And we typically include a clause in our wills that talk about gifts to minors under a certain age. What's important is in my view, is some sort of ability for a gift to a minor to be paid to, for example, the parent of that minor, some other person other than the trustee, who might not want to get stuck with managing this money for that person. And so the key is the key is the clause that talks in the middle of that section, paying it to another person who becomes a successor trustee. So they would have all the powers of a trustee to deal with that. And that is the discharge to the trustee, the executor who's paid that amount out. So that's an important provision. And like I said, in ours, it's sort of embedded in the provision for younger beneficiaries under a certain age. Now, legacies, unlike residue, there's a timing aspect to it. And the rule is, it's called a rule of convenience. And although you'll see it might not be that convenient, the rule is that unless the will says something different, a legacy, a specific amount, is payable within the first year after death, what's called the executor's year. And if it's not paid within that year, it will begin to earn interest until they receive it. And nowadays, and what is the interest? The interest is 5%. So let's say there's a $150,000 legacy or $100,000 legacy. Let's make it easy on myself. And you apply for probate, and the only asset is real estate, and probate takes 8 months, and it took a few months to get the application in, and then you got to sell the property, and by the time you sell it, you got to pay everybody else out, and okay, now you're ready to make this legacy, and it's 2 years, it's the second anniversary. This person would be entitled to $105,000. And even if the residue was wasn't earning any money, because there was no money there and et cetera, it doesn't matter. It is a rule of convenience that applies, and it always applies. And it's not, well, is it fair? Is it reasonable? What did the residue earn? No. And in this recent case from the Court of Appeal in 2018, the court said that, because what had happened in that case was the whole administration had stopped because there was a will challenge. And it took, I don't know, 4 years or whatever to solve that will challenge. And now, okay, the will is valid, let's pay out the legacies. And the legatee said, well, we're entitled to interest. And the estate trustees and the residuary beneficiaries said, no way, we didn't even know what will was valid. You're not entitled to it. The Court of Appeal said, yes, you are. So it doesn't matter what the reason is, you start doing that. So how do you deal with that? Well, you could put a contrary intention in the will. And you could say, look, I direct that there's no interest payable on that legacy, regardless of when the payment is received. And as long as it's not paid before, or it's not paid after the residue. So you can't sort of screw the legatee, pay out all the residue and say, well, I don't have to pay you interest ever because it says I never. So I thought this was a good compromise that says, look, you don't have to pay interest as long as you haven't made another distribution. And the last issue is the idea, and this is a dangerous one, of duplicate gifts in wills. And so both husband and wife, you do their wills, and they each want to leave $150,000 to Liz or to charity or whatever, if your spouse is not alive, so on the second death. But they die in a car accident, and they both die, and your will was silent about that, so there's $150,000 paid out of each will, and now the charity's getting $300,000. And of course, the residuary beneficiaries, who are the same under both wills, say, well, that's not what they meant. And the charities say, yes, that is. And there's a claim against the lawyer for drafting it that way. So what do we want to do to avoid that? We don't want that to happen, obviously. And that is especially relevant if you're talking about if you have in your will a survivorship period, like the spouse only gets it if they are alive on the 30th day, et cetera. So what We do, and eState does this automatically. It recognizes where there are matching gifts in both the spouse's wills, and will automatically put in this clause that says, here, if my spouse's will has a similar provision, if we die at the same time, or in situation where the payment of that legacy would be paid twice, we don't want that. We want to automatically reduce the amount either by half, as long as there's enough money to pay both 50-50, or so it's only paid once. And that's covered. So that's something that you want to have on your checklist. And certainly if you're doing it manually, you want to remember, oh, I've got to put this clause in because I'm making a similar gift to the other. There's a similar gift in my spouse's will. So that is our half hour. I'm going to just look at some questions now, if we can. And I'm going to just change this. And let me, I wanted to do one thing. So let me just generate a multiple will here. So this had the legacies in it. And I just want to address one drafting issue for legacies in multiple wills while I look for the, let's go to chat. So, residence of donor or beneficiary. It's the residence of the testator. So that's the first question. Jordy, did you mean to say if there's a documented loan, you don't need Hodgpod? Yeah, the problem is if that debt is not payable for some reason, there's some defense to it, et cetera. But if you think about it this way, I mean, it's a debt that's owing to the deceased. It's an asset in essence. So they would have to pay that back. I mean, they're not excused from that. So yeah, if there is a documented loan, you don't necessarily need Hodgpod, but you may want to do it and forgive the loan and do multiple wills and things like that. But yeah, my view is that if you've got and you're sure that's legally enforceable, that you should be okay with that. Let me just see. The next issue, let me just do one other thing. So this is the document that was just generated with the gift. Let me just show you what I want to show you. So here we did the multiple wills. This is the primary will. But what we don't want is, and we typically put the legacy, I'll just show you this. We've got the legacy here. Here's the legacy to Elizabeth. It's in the primary will, right? But we don't want there to be, let's say everything's in the corporate will and there's no money to pay the legacy in the primary will. So what you're going to want to include is a clause that says this, that if the amounts that pursuant to paragraph 11 are not satisfied, then what I want you to do is satisfy them out of the secondary will, but make sure it's only satisfied once. So that's how to draft around that. And obviously that would be automatically generated if you're using eState. So next question was, what obligation, if any, does a solicitor have to record the gifts or loans? Is it sufficient to advise client to ensure that written record is kept? What happens if the amount which is written down is disputed? Does the beneficiary have to acknowledge the loan or gift? So these are very simple, but very difficult issues because it seems really simple. We just want to take these into account. They can be very, very difficult. So yes, I would want the debtor to acknowledge it. That would be very helpful. I don't think we needed to record those loans or gifts. I mean, it would be helpful if we raise it. One of the things that, you want to always ask a client with, let me just see, this is a warning that comes up. It asks me as the user that you want to confirm that there's not made loans or advances to the client. And if they are, should they be repaid, forgiven, or hodgepoded? So definitely an issue to be considered and raised with the client. I raise it with every time just to cover it off because this is a simple issue that can be very complicated. I think it's sufficient to advise the client to ensure there's a written record, but obviously it's something I would want to canvass with them and just find out. And maybe they say, well, right now we don't have anything, or we do, but we think there might be future ones. So that's the idea there. John Hodgson raised a good question. Is it the residence of the testator at the time of the will or the time of death? I would say it's the time of the will, but we can go back to that Saunders case. There's really not much written on it about it. It's really the intention of the testator. And I think if you look at the testator, if you're doing this, the armchair rule, it'll be the date of the will, not, or like the residence at the time of the will, not at the date of death. So, so those were great questions, by the way. So thank you all we will send the slides around. If anybody's interested, if anybody has I've got a few minutes. If anybody has any other questions on this topic, be happy to answer that. Otherwise, we'll hopefully see you next week, and we'll talk about bequests and drafting around those. So thanks so much.